5 seconds to go. Start. Similarly, in Yaqub versus State of Maharashtra 2013 SCC 1, this Honorable Court, while dealing with the award of the death sentence to persons convicted inter alia under various IPC offences, including waging of war against the Government of India and the Prevention of Terrorism Act, discussed the wide ambit of the term terrorism and held that the offence of terrorism itself was an aggravating circumstance. The term terrorism is a concept that is commonly and widely used in everyday parlance and is derived from the Latin word terror, which means the state of intense fear and submission to it. There is no particular form of terror, hence, anything intended to create terror in the minds of general public in order to endanger the lives of the members and damage to public property may be termed as a terrorist act and a manifestation of terrorism. Black's Law Dictionary defines terrorism as terrorism is a global phenomenon in today's world, and India is one of the worst victims of terrorist acts. Terrorism has a long history of being used to achieve political, religious, and ideological objectives. Acts of terrorism can range from threats to actual assassinations, kidnappings, airline hijackings, bomb scares, car bombs, building explosions, mailing of dangerous materials, computer based attacks, and the use of chemical, biological, and nuclear weapons, weapons of mass destruction. Crime of terrorism is in itself an aggravating circumstance as it carries a special stigmatization due to the deliberate form of inhuman treatment it represents and the severity of the pain and suffering inflicted. In Kasab vs. State of Maharashtra 2012-9 SCC 1, this Honorable Court, while convicting the appellant therein for the terrorist attack of 26/11 in Mumbai, stated that facts of the case, the cross-border conspiracy, and the intention to strike fear into the heart of the victims, that the death sentence was warranted. While the court recognized that death should be the exception, this Honorable Court noted that as long as the death penalty remained on the statute books for crimes such as waging of war, there would be certain cases where its imposition would be justified. In this regard, attention is respectfully drawn to the following paragraphs. In short, this is a case of terrorist attack from across the border. It has a magnitude of unprecedented enormity on all scales. The conspiracy behind the attack was as deep and large as it was vicious. The preparation and training for the execution was as thorough as the execution was ruthless in terms of loss of life and property, and more importantly, in its traumatizing effect. This case stands alone, or it is at least the very rarest of rare cases to come before this court since the birth of the Republic. Therefore, it should also attract the rarest of rare punishment. Putting the matter once again quite simply, in this country, death as a penalty has been held to be constitutionally valid, though it is indeed to be awarded in the rarest of rare cases when the alternative option of life sentence is unquestionably foreclosed. Now, as long as the death penalty remains on the statute book as punishment for certain offences, including waging war and murder, it logically follows that there must be some cases, howsoever rare or one in a million, that would call for inflicting that penalty. That being the position, we fail to see What case would attract the death penalty if not the case of the appellant? To hold back the death penalty in this case would amount to authoritatively declaring that this court rejects death as lawful penalty even though it is on the statute book and held valid by the constitutional benches of this court. No ground for review of the death sentence is made out as the three tests stand fully satisfied. All three courts have recorded elaborate reasons for why the present case was one which warranted the death sentence and have considered the crime, the criminal, and whether the case could be said to be the rarest of the rare. This Honorable Court has recorded elaborate findings in the judgment presently under review on sentencing as to why the present case satisfies all three tests, including the rarest of the rare test. Firstly, this Honorable Court found that the nature of the crime, being an attack on the Red Fort, was nothing short of an attack on Mother India itself. Secondly, that so far as the nature of the criminal was concerned, no mitigating circumstances of any kind had been brought on record, and thirdly, that the nature of the crime, the fact that it was a planned, premeditated attack on a symbol of the seat of power of the government of India, warranted nothing short of the highest punishment. Stop.